प्रिय साथियों नमस्कार, मैं डॉक्टर जी के गोस्वामी और आप देख रहे हैं हमारा चैनल UPSIFS लखनऊ। ये आपकी सीरीज वाला सेशन है जिसमें हम लाइव स्ट्रीमिंग में आज चर्चा करेंगे रेप रिलेटेड प्रेगनेंसी। मैंने एक छोटा वीडियो भी इस पे किया था और आपने देखा होगा कि बहुत बार रेप के मामलों में, चाहे वो अडल्ट महिला के साथ हो या पॉक्सो के मामले जिनमें बच्चों के साथ सेक्सुअल ऑफेंस होते हैं, उनमें ऐसी घटनाएं भी होती हैं जहां रेप की वजह से जो पीड़िता हैं, जो रेप सर्वाइवर हैं, वो प्रेग्नेंट हो जाती हैं। और कई बार शारीरिक संगठन की वजह से या और भी बहुत से कारणों की वजह से जो प्रेगनेंसी का डिटेक्शन बहुत लेट होता है, तो ऐसे केस भी देखने में आते हैं कि मजबूरी बस रेप पीड़िता को उस बच्चे को जन्म भी देना पड़ता है। ये भी देखने में आया है अमेरिकन स्टडीज में कि 5% मामलों में रेप के महिलाएं या पीड़िता रेप की वजह से वो प्रेग्नेंट हुई और कई बार उन्होंने बच्चों को जन्म दिया। तो वी विल टॉक अबाउट प्रेगनेंसी रिलेटेड टू रेप, RRP, rape related pregnancy. So friends, we'll talk today rape related pregnancy, a global socio-legal challenge. This is a problem at the global landscape. This is not only in particular area, but most of the time in war infested countries, the rape is used as war weapon. So this is yet another facet of rape. Basically, RRP or rape related pregnancy, as I mentioned, that pregnancy add pinch of salt to the injury of a rape survivor. The lady or the victim had already underwent a very traumatic phase of rape, and if she came to know later that she got impregnated, that is the worst thing to happen. The sexual violence challenging reproductive autonomy. This is yet another facet, that the reproductive autonomy of the person, of the survivor, is also challenged. And always there is a challenge for access to justice. As I already mentioned, that 5% of rape result in pregnancy. This is a study in America in 2003. I already mentioned that in conflicted zones such as Rwanda, Bosnia, Congo, it has been observed that rape has been used as war weapon just to traumatize females, and of course many of these rape survivors, they get impregnated and they are forced to give birth to the child because the rape survivor in many countries are not permitted for abortion. So if you remember, we have discussed the issue of choice versus life, right? So whether you prefer the choice of the lady, this is a modern concept, and the debate of the child is the gift of the God, right? So this is a tussle between these two things. There are legal barriers, there are strict abortion, as I told, pro-life and pro-choice approach. This is a conflict, and we have discussed this conflict in a great detail in our previous deliberation. For abortion, the burden of proof lies on the rape survivor. This is yet another problem. The rape survivor has to prove that the pregnancy to which she wants to abort is the outcome of rape only. So this onus or this burden of proof lies on the shoulder of the rape survivor. And to prove this, lot of time is wasted, and sometimes the age of the fetus cross the limit of 24 weeks, and afterwards the termination of pregnancy becomes medically and legally difficult. So this is the very, very important things to learn. There is social stigma and victim blaming. As you know, across globe, the rape victim are being ostracized many times. They suffer from self-blaming also. So ultimately there is a huge discrimination in the life of rape victim. The husband also, it is learned that the rape survivor is abandoned. They are generally left all alone without means to carry. So these are real challenge. There are certain cultural taboos and patriarchal society. As we know that these cultural taboos are there. The RRP-led ostracism, I told that they are being abandoned by the family, by the society, and they becomes almost orphan. Then it is the limited access to emergency contraceptive. As I told that in pro-life approach, even the contraceptives are not being permitted. And particularly Wade case, Wade versus Roe in 1973, the contraceptive were permitted, abortion was permitted, so that was a very progressive case. But in US, in year 2022, in Dobbs case, again, the pro-life approach was established and abortion has been denied. The contraceptive have been denied to the female to avoid pregnancy. So this is the latest status, and Dobbs case we will discuss sometime in detail. So the rape-related pregnancy is not only physical trauma, but it is mental trauma also. So these are the issues and challenges basically. So let us understand one another concept. Rape is basically where the sexual act is committed without consent and by using threat or force. So that is rape. But in coerced sexual liaison, maybe within the marriage, the marital relationship, or for various other, dating and other relationship, there are sexual coercion related pregnancy. That means pregnancy may be rape related and sexual coercion. Sexual coercion means there is no consent of the female partner, but male partner is so dominant that she cannot refuse. So that is sexual coercion related pregnancy. Here I have given a kind of comparison between these two. Let us see very quickly whether threat or force is used in case of rape. The answer is yes. But in sexual coercion related pregnancy, not necessarily direct force is used, but there is no consent. So consent is missing both in rape as well as coerced sexual related pregnancies. Legal framework in most of the country, rather in all country, rape related laws are very well defined. But there are hardly any specific legal framework for coercion related sexual behavior and the pregnancy. They are generally used in domestic abuse type of legal framework or the reproductive coercion. So this is an evolving legal framework. Likewise, the common perpetrator in rape, they are strangers, they are sometimes non-assailant, particularly within family, maybe relative, maybe some, boyfriend or something like that. But certainly in sexual coercion, it has to be known person, there may be partner, there may have intimate relationship, but without consent. Ground for abortion, in rape-related pregnancy, it is explicitly allowed. Like in India, we will talk in MTP Act 1971, there are specific provisions we will discuss, but in sexual coercion-related pregnancy, there are not specified provisions for termination of pregnancy. That's the difference. Let us talk about a part of statistics, and these are the references from where I have picked up the statistics over here, and these are the very latest study as early as 2024. It denies V.D. Angelo. He observed that 1 in 20 women in United States experienced either rape or sexual coercion-based pregnancy. So, that means 5% pregnancies are coerced or rape-based pregnancies. 1 in 7 female vaginal rape victim and 1 in 6 female sexual coercion victim becomes pregnant due to rape or sexual coercion. So that is the statistics in general. That means by and large 5% pregnancies are rape related or coercion related sexual liaison. The National Survey of United States in 1996 also said the same, that 5% rape cases get converted into pregnancies. 51.8% women who reported intimate partner rape experienced rape-related pregnancy. So these are the statistics. By and large, you can see it sometime. Now, let us talk about the abortion, because as a matter of right of rape survivor, if the age of fetus permit to get aborted, then only abortion may be done. Secondly, not in all jurisdictions abortion is allowed. Like I said earlier, that in United States, after Dobbs case in 2022, now again the pro-life approach has been established and abortion has been banned in many countries. Not even contraceptive medicines are being allowed. So now again the square zero, the situation is like pre-Roe case. In general, abortion is a social term to terminate pregnancy before birth of individual, which is an unborn child here. The statute across jurisdictions usually have not defined abortion. However, legally speaking, abortion is basically termination of pregnancy, and in United States, no federal statute define abortion, but after Dobbs case, as I told, Texas Health and Safety Code have defined abortion as mentioned on the screen, and I will read out. Abortion means the act of using or prescribing any instrument, drug, medicine or other substance or device with the intent to cause death of the fetus in the womb of the female. So this is the by and large definition of abortion. This is the legal status. Country like US, they have statute but no statute at the federal level. It means abortion is the state matter. So certain state has legal provision to permit abortion. The relevant provision I have mentioned in few states. So if you have interest, you can go state by state. However, provision for rape survivor in some state, abortion allowed for rape survivor. But if I summarize in United States, after Dobbs case in 2022, the permission of rape is very, very limited, only on the ground of medical health of the female or medical or physical health of the fetus. So these are the only limited areas, not by the choice, like pro-life and pro-choice. Now it is again the preference is for pro-life and not for pro-choice. In United Kingdom, the Abortion Act of 1967, which has been amended completely and has been renamed in 1990, the section 1A and 1B deals with rape-related pregnancy and it allows abortion up to 24 weeks. My dear friends, in general, the gestation period up to 24 weeks is permitted, although there may be some health challenges, but this is generally a cut line, 24 weeks. Afterwards, the health of the female get affected badly. So only based on doctor's advice, the termination may be permitted. However, in Indian scenario, we will tell that up to 20 weeks, one RMP, that means advice of one registered medical practitioner is required for the fetus of the age 20 weeks. From 20 weeks to 24 weeks, you need to have the advice of the two RMPs, and afterwards, after 24 weeks, the medical board on the pretext of the court can only advise, and the court has to give order for termination of pregnancy. So that becomes very stringent law. In India, as I told, the MTP Act of 1971, which has been amended after 50 years in 2021, section 3, subsection 2, part B, and particularly explanation 2 says that rape survivor has right to terminate the rape-related pregnancy. This is the scenario in India. In Australia, in Germany, in South Africa, I have given a table. I will upload this table on my ResearchGate as well, so you can see, you can do, and you can make notes if you want. So because of the paucity of time, I am just skipping for few discussions. Friends, as I told that in many countries, the pro-life approach is preferred over pro-choice, and these are the countries because of the prevalence of Bible and Quran and many other religious texts. It is considered that life is created by supernatural power, maybe God, maybe Jesus, maybe Allah or whosoever. So the life is created by supernatural power and human being has no authority to take away the life, and that is the core of pro-life approach. However, pro-choice says that it is my body, it is my choice whether I get impregnated or not, whether I want to deliver the child or not. So this is a modern concept, and pro-choice and pro-life debate is always pondered, and sometimes arguments are more in favor of pro-choice or alternatively pro-life. But after Dobbs, pro-life dominate. So these are certain areas, certain jurisdictions, certain countries like El Salvador, Haiti, Jamaica, Malta, Suriname, Philippines, Egypt, Senegal, Iraq, Syria, Yemen, UAE, Saudi Arabia, and list is quite exhaustive. That means a large number of countries follow that abortion is not permitted, including rape-related pregnancy. Now, let us see global scenario further. What is the legal issues? So, initially we will talk about the international platform, how United Nations, human rights bodies, the Convention of Elimination of All Forms of Discrimination Against Women, CEDAW. CEDAW, since 1979, has set a tone actually to strengthen the rights of the female across globe. So, CEDAW is very, very important instrument for asserting rights to the woman. Then the Human Rights Committee, ICCPR, in KL versus Peru and Meerut versus Ireland found that denying access to abortion constitutes cruel, inhuman and degrading treatment. That means that if you do not permit abortion to the rape survivor, that attitude itself amounts to cruel, inhuman and degrading. So that's the beauty of ICCPR and other human rights instrument. Likewise, UN Security Council Resolution 1325 in year 2000 recognized the disproportionate impact of armed conflict on women and children. These are the real challenge. And whenever there is any conflict, there is any war, children, old age and women, they are the most affected lot in the society. Then on third protocol, Menupato in Africa, Article 14 of African Constitution deals with abortion in case of sexual assault, rape and danger to life or health. Inter-American Court of Human Rights also deal with this. Now let me talk about Indian legal regime. As I mentioned that Medical Termination of Pregnancy, MTP Act 1971. Again I repeat, MTP 1971 deals with rape-related pregnancy and provide right to the rape survivor for abortion. In general, Section 3 talks about when pregnancy can be terminated by registered medical practitioner. RMP means registered medical practitioner. In general, it says that Section 3, subsection 2, length of pregnancy should, if it is 12 weeks, then you need to have the advice of 1 RMP. If it is up to 20, then 2 RMP. However, this has been changed in 2021 because of the, advancement of technology in medical science and many more. Now things have been changed, so we will talk about. But important here is for explanation 1. Explanation 1 especially provide the right and enable a rape survivor to undergo medical termination of pregnancy due to rape. So, explanation 1 deals with rape survivor. However, explanation 2 deals with right to a woman who got impregnated due to failure of contraceptive device like condom or any medical contraceptive. It doesn't work and she get impregnated, then explanation 2 operate, and this is mainly related to family planning, so that the child birth is controlled by the parents or the female who carries the pregnancy. These are certain important areas. The gestation limit up to 20 weeks, we need to have 1 RMP up to 21 weeks, and that is particularly for 20 to 24 weeks. Now I am talking this because of or as a consequence of the amendment in 2021. Amendment 2021. So now up to 20 week it is for 1 RMP. If the gestation period or the age of the fetus is 20 to 24 week, then 2 RMP, and after that you have to go for court order, and court will consider termination of pregnancy based on the advice of the state medical board, right? Who can terminate? Only a registered medical practitioner, not any Neem Hakim or any like non-professional medical practitioner. Ground for termination: in general, the risk to the physical or mental health of the pregnant woman, substantial risk that child would suffer serious physical or mental abnormality, pregnancy caused by the rape or incest. So these are the grounds for termination of pregnancy. The privacy clause: the identity and detail of the woman undergoing termination of pregnancy must be kept secret. The doctor is duty bound to keep secret, and the doctor cannot disclose the details, name and any other identification of the woman who underwent abortion. That is very much part of MTP Act. Then expansion of beneficiary: it include unmarried woman, which was not earlier. Then medical board: I told you that medical board at state level is required if the term of the pregnancy is more than 24 weeks. The safe and legal abortion: this act aims to ensure safe abortion. Otherwise, if you do not permit, then the female will go to the local doctors, those who are untrained, and just by quacks, the life of many females are in danger. So this provide you the proper right to go for abortion if you meet certain conditions necessary. No abortion on demand: abortion cannot be just based on demand. Abortion is allowed solely on request. So this is the salient features of amended act. Most of them I have covered, which I again repeat, that for the gestation period of 20 weeks, 1 RMP advice is necessary. For the gestation period of 20 to 24 weeks, you need to have the advice or recommendation of 2 RMPs, and afterwards by court order based on the advice of the state medical board, right? Then medical opinion required: I have already mentioned all these things, so this is almost covered. Comparison of medical board: you have to, what is the composition? You have to have a gynecologist, one pediatrician, so that they can see the status of the child, then radiologist or sonologist, those who can see the womb, the status of the pregnancy or the fetus, then other specialists as required. This act or amended act of 2021 has included unmarried women also. Those females, those who are unmarried and want termination of pregnancy. That is the additional thing, or you can say the forward-looking provision in this act. Then protection of privacy is also very important under section 5A, which has been introduced. That means that doctor is duty bound not to disclose the identity of the female who underwent termination of pregnancy. That is very much important, and you must be knowing that privacy is now integral part of right to life under Article 21. This has been announced, or this has been established by K.S. Puttaswamy, retired judge, versus Union of India in 2017. The Amendment Act is woman-centric. It shifts decision making more toward the woman. Now, you just see how progressive it is that even a unmarried woman may go for abortion. That is the forward-lookingness of this amended Act 2021. Just a minute, there is some technical glitch. Let me just find out some solution. इसका चार्ज चला गया तुम लोग जो है ना Sorry for some technical glitch. The power supply was interrupted. So let's again start. So these are certain areas, as I told, that the MTP Act Amendment 2021, it is women-centric, it reduced litigation, and it has emphasized on reproductive right. So if I put and compare with current US situation in India, I think India is more progressive. The MTP Act is much advanced if we compare with DOPS in 2022. And see, the Roe versus Wade, it was in 1973, but MTP Act was enacted in year 1971, almost 2 years prior to Roe versus Wade. And that was having the permission for abortion, not only for rape survivor, but for other persons also. So that's the beauty of Indian law. Now if I compare between MTP Act 1971 and the amended Act of 2021, then the gestation period, earlier it was up to 20 weeks, now it is up to 24 weeks. And by the permission of the court, in consultance with the state level medical board, it may be beyond 24 weeks also, right? And opinion, as I told earlier, it was up to 12 weeks 1 RMP, and for 20 weeks it was 2 RMP, but in the amended Act 2021, for 20-week gestation period of pregnancy, 1 RMP, up to 24, 2 RMP, and beyond by the medical board on the court order. And ground for abortion, as I told, that it may be the health status of the woman and the fetus as well. And the most important addition in Amendment 2021 is inclusion of unmarried women to permit for abortion. That's the most advanced happening. As I told, inclusion of unmarried women, then formation of medical board. I told already confidential provisions have also been specified in MTP Amendment 2021 one which was not there. That means section 5A has been introduced in this amended act. Then it provides reproductive autonomy. So it is more and more towards liberalism for the female. Then it has special categories, special provision for vulnerable women, including rape survivor, differently abled, minor victim, incest, and others. Then legal intervention often required court intervention, but this intervention has been reduced significantly in amended version of 2021. Then alignment with international laws. We have allied our MTP Act with the international standard of United States and all. Now, I give you some anecdotes by the researchers who have really contributed significantly. So, one anecdote which really shake the consciousness of everybody, at least to me, it shake my inner feeling. Professor Andrew Solomon, who is a very renowned feminist and a professor in Columbia and Yale University, she has mentioned in her article The Legitimate Children of Rape, which has been published in 2012 in the New Yorker. You can download it and can see also. It has given certain stories, the anecdotes. She mentioned that when she was undergoing some empirical study on the females who underwent a rape trauma and coupled with rape-related pregnancy. So she narrates a story of Meerut, who was 20-year-old Albanian lady and was abandoned because she was raped during Kosovo struggle. She got impregnated and she was actually raped by a Serb. When the term of the pregnancy matured, she gave birth to a very healthy male baby in a government hospital, and the nurse gave the child. And here is the catch point, my dear friends. When she embraced the child, when the nurse gave, generally it happens in the hospital that when the baby is born and the mother gets some, condition to hold the baby, then they generally present the baby to the mother, generally. So the nurse, by way of affection, did the same. The rape survivor, who was in the maternity ward, just delivered the child, took that baby and see the face, and immediately she tore the neck of the baby. So she cradled him to her chest, she looked into her boy's eye, she stroked his face, and she snapped his neck. You just see the pathetic mental situation of a rape survivor. I think nothing can be worse than situation of this to a female, the rape survivor, who has suffered first the rape, then suffered with pregnancy, and now deliver a baby. And when see the face of that child, she recognized that she is the outcome of the rapist, and that is why she did this criminal act. And of course, because it was a murder, so she landed into correction home. And psychiatric actually observed about Meerut. They observed that she may have looked into the baby's face and seen the eyes of Serb who raped her. So this is the pathetic situation. And I also have interviewed few rape victims who have given birth to child. I have also observed that the feeling of the rape survivor towards the child born to them are totally different than a normal mother. And you will see another anecdote which is again will shake your consciousness. She again says that a Rwanda rape survivor gave birth to a female child. During an empirical study, when Professor Andrew was undergoing. So that lady asked, the rape survivor asked, and quote, "Can you tell me how to love my daughter more?" She further asked, "I want to love her so much and I try my best, but when I look at her, I see what happened to me and it interferes," unquote. That means that psychology of a mother is very much there. The basic instinct to love the child is very much there. But once she recollects the event of rape, her complete that motherhood, the love towards child get vanished, and she is not in the state of mind to love that child. And she says, "Can you tell me how I can love my child more?" So that is this is the red color I did. Can you tell me how to love my daughter more? So this is the sentiment. Now let me talk about the evidence point of view, because I am a police officer, and now here we are talking the various dimensions of rape related pregnancy. So in case of rape related pregnancy, the evidence is very much evident to prove rape, because the fetus, if it has been aborted or if the child is born, in both cases in the modern era, DNA is the suitable technology, the forensic tool by which you can connect the rape crime with the rapist. So this is the very important part. Let's see what we can do. So termination of pregnancy, it is advised, rather it must be done, that whenever a medical doctor or medical registered practitioner conduct the abortion or the delivery, they should collect the DNA sample so that it can be referred to the forensic laboratory for comparison of the suspect, the mother and the child. So that is, the sample should be collected. Then birth of child, duty of police to examine, the medical examiner and prosecutor. So these are the people who are also aware about these facts. So they should also be updated about the latest, what is the report of DNA and all. Consent of victim for DNA sample. In Indian scenario, the consent to collect, even not only collect the DNA sample, in Indian scenario, section 53A of CRPC was dealing with the medico-legal examination and collection of DNA sample of the accused. And here, consent is not required in case of accused. But on the other side, section 164A, I repeat, section 164A of CRPC, that deals with the medico-legal examination of rape survivor and collection of DNA sample for matching. Here consent is necessary, and consent should be in writing. Consent should be informed. And in case of minor rape survivor, the consent should be taken by the parent, legal guardian. In case neither parents is available nor legal guardian is available, then matter must go to court so that they can depute a person as guardian, or court itself may act as guardian, right? So that is most important part before you conduct medico-legal examination or collection of biological sample for DNA analysis of a rape survivor. These are certain important observations for the investigation point of view. Forensic opinion including DNA report is corroborative. It is a secondary evidence, and corroboration or circumstantial evidence, right? Positive DNA report has strong inculpatory evidence. That means that if the DNA report is matching with the rapist or the accused, then it has the positive impact, or it has strong inculpatory evidence. However, negative DNA report may not be solely enough for acquittal. Why? Because there may be so many reasons that ejaculation may not be there, penetration may not be complete, the person may be spermatozoic, and many other reasons. So, positive DNA report has more weight for conviction. On the other hand, negative DNA report may not be enough for acquittal of the accused. Bombay High Court has observed, especially on the strength of DNA, what it says DNA would constitute clinching evidence against the accused if, however, the result is negative. The other material available on record will still have to be considered independently. That means that if report is negative, then solely you cannot acquit because you have to see other evidence for purpose of corroboration. And there are so many cases which the latest I mention here, Abbas Asmat Ali versus State of Maharashtra of 2022, Bombay High Court. There are certain more case laws. In X versus Government of NCT Delhi of 2022, Justice D.Y. Chandrachud, who was the Chief Justice also, he observed, and the similar observation was also by the Honorable Supreme Court in Suchita Srivastava versus Chandigarh Administration. I tell you, this case, Suchita Srivastava, is again very, very prominent. In X versus Government of NCT, Justice D.Y. Chandrachud says, quote, women's right to reproductive choice is an inseparable ingredient of her personal liberty under Article 21 of Indian Constitution, unquote. Similarly, in Kusal Marapi versus State of Chandigarh in 2024, Chhattisgarh High Court, quote, the court says, quote, DNA helped to connect the rape accused with the pregnancy or the child to the prosecutrix, thus facilitate conviction. That means that if you link by DNA the rapist with the fetus which had been aborted or the child which had been given birth, in both cases the DNA will be a very potent tool to prove guilt of the accused or to connect with the accused. It is extraordinary power of court to order termination of RRP that has been reinstated in X versus State of NCT in 2022. In rape investigation, a DNA test is aimed to trace the perpetrator and not to decide paternity. This is also important because here Section 112 of the Indian Evidence Act deals with presumption of paternity of a child. In rape cases, we are not determining the paternity. Basically, we are determining who is the rapist, who has contributed as male component in the child, right? Because half portion comes genetically from mother, who is the rape survivor here, and the other one is the rapist. So that is the point. In Deepak versus State of Haryana, the Honorable Supreme Court of India in 2015 says that threat to rape survivor for non-disclosure of fact related to offence remain a major cause for delay in reporting as well as late detection, because the rape survivor is so threatened, under such fear, and sometimes the rapist may be known person, maybe from the family. Hence, and especially in case of children, it is very, very difficult to a child to disclose that she has been molested or sexually abused, because even the family member may not believe. So these are really mental block, and that is why the time delays and the pregnancy cross 24 weeks time or like that, or maybe the physical condition of the rape survivor may not permit for abortion, and unfortunately such rape survivors are forced to deliver the baby. There are plethora of cases where prosecution failed to conduct DNA. Yes, this is another point. And I reiterate again that now in the era of the new criminal laws which have been implemented from 1st July of 2024, Section 176 of BNSS has ensured that the forensic evidence has to be collected mandatorily by the forensic expert by way of visiting the crime scene in heinous crime, particularly those offences where punishment is either 7 years or more. Meaning thereby now forensic science is on the forefront, and it is not to be conducted by the police officer, which may not be a properly trained or may not be expert. So collection of evidence from the crime scene has to be done by forensic expert as per the intent of the Indian Parliament reflected under Section 176(3) of BNSS 2023. So these are judgment. Again, some important judgment. I have given a comparative study. I generally believe that lot of students, lot of faculties, they want a comparative chart because that is very easy to remember and to compare also. So that is my habit generally, to give a comparative chart. So these things I have already covered. So there is no need of taking much of your time. These are all judgments which we have discussed. As I told, you can visit my other articles on ResearchGate also. I keep posting on LinkedIn by my name, and you are seeing our website here, that is YouTube channel. You please subscribe this and you will get so much of material. Now let us compare few cases of US court and other court as well. Roe versus Wade, as I told, in 1973, that was a very, you can say, forward-looking judgment which made, thumping entry on the global landscape. The question in this judgment or this case was whether the US Constitution protects women's right to choose abortion. The ruling was yes, the abortion was legalized under the right to privacy, and the constitutional provision was 14th Amendment covers this right to be exercised. However, in another important case of 1992, Planned Parenthood versus Casey, it was told, or the case was, whether validity of Pennsylvania abortion restriction is valid or not. The court says that yes, Roe versus Wade is constitutionally valid, but it has replaced trimester test with undue burden standard, right? In Dobbs versus Jackson Women Health Organization, 2022, again the clock went to 0 and Roe versus Wade was nullified. So now Dobbs versus Jackson Women Health Organization prevails. That has overruled Roe and Casey, and it says that there is no specific explicit constitutional provision in US federal constitution, and that is why again the pro-life approach prevail over pro-choice. These are the judgments in the United Kingdom. R versus Borne, a landmark pre-abortion act case, and in this case a doctor was acquitted for performing abortion on a 14-year-old rape survivor. So, and it was very old case of 1939. So that time UK was also observing pro-life approach, but doctor, for the benefit of the rape survivor, underwent or conducted abortion procedure and he was prosecuted, but he was acquitted by the King's Bench. Then another important case is Patton versus British Pregnancy Advisory Service. The fact of this case were the husband tried to sought order to prevent his wife's decision for abortion. The wife want abortion, husband was not ready. However, the Queen's Bench said that it is the legal right of the woman. Husband has nothing to intervene in the right to prefer whether the wife wants to abort the pregnancy or to deliver the child. So that is again very modern preposition. C versus S in 1988, Queen's Bench held that a fetus has no independent legal right before birth. I think this is again global phenomena. Regina F in utero in 1980, it says that unborn child has no legal personality and court has no jurisdiction over a fetus unless it born alive. Likewise, in Northern Ireland Human Rights Commission in 2018, the Supreme Court held that Northern Ireland abortion laws breaches Article 8 of ETCHR. It influenced decriminalization in Northern Ireland. So these are best practices. Now we are almost to the conclusion slide. Access to immediate care to rape survivor. They should also be given the pregnancy test till there are any possibility, and in case pregnancy is detected, then timely the abortion, if required, may be conducted. Then rape survivor protection laws must be in place. Decriminalization of abortion for rape survivor. In many states, I told that abortion is completely proscribed, irrespective of whether she underwent rape or not. Then education and awareness. Yes, this is very important because until unless you know your right, how can you exert? We have to develop victim-centric approach, and I think there is a trend in the global scenario, and our own country, India, has completely wiped out the 3 criminal laws which were having British legacy, and now we have Indianized our criminal laws, and from July 1st, 2024, we have implemented them. Then timely detection of RRP, I always say that many a times the girl or the female may be of tender age, may not be knowing the changes in the body due to pregnancy, and it gets delayed, and various other issues keep daunting. Every rape survivor should provide pregnancy detection kit. This is my suggestion, that every rape survivor, when underwent medical legal test, she should be given some kind of device or some test by which the pregnancy can be detected timely. So now almost I spent around 1 hour with you. I am so thankful and grateful that you always appreciate our effort of disseminating knowledge on various dimensions like forensic science, law, sociology, and allied subjects. Cybercrime, cybersecurity are also facets of this platform. We are committed, dedicated to provide pro bono, education, knowledge, and sharing experience, so that largely we benefit with each other's experience. So please, once again, I thank you and request you to subscribe the channel and share with your friends. You can visit my ResearchGate to find more articles and presentations for your larger benefit. Thank you. Dhanyawad.